I'm innocent. I didn't do this. This is probably one of the most important things that I can impart to you if you're either a criminal defendant, target of an investigation, or if you want to know about the criminal justice process. It's extremely important. And I'm making this video because day in and day out, I deal with the statement, I didn't do it, or I did something less than what I'm charged with. Why is it so important? Contrary to what many may believe, if you are a potentially new client and you go to your lawyer and you say, I didn't do it, that I'm innocent, of which there are people who clearly are, in fact, innocent of all the crimes they've been charged with, or maybe some of the crimes, doesn't really make a difference. You have to be prepared when you're looking to hire a new lawyer, or a lawyer in particular for that charge, is to say, will you go to trial with this case? Why am I mentioning this topic? Because we receive calls, multiple calls every week by dissatisfied clients with other law firms where they told the lawyer from the beginning they didn't do it and that they were innocent. The lawyer took the money, they entered into a retainer agreement, and then maybe a month or two down the road, when a plea offer is offered by the prosecution, critical stage of the case, the lawyer pulls the rug out from underneath and says, I'm not here for a trial, I'm here for a plea bargain. Listen to what I'm telling you, goes on over and over again. There's a difference between a trial lawyer and a plea bargain lawyer. Not that plea bargains are not appropriate, but you need a lawyer that is willing to go to trial. Now, especially if you tell the client in the beginning of the case, I didn't do it, I'm innocent. I always tell a client that says that, well, then it is going to go to trial if the prosecution isn't willing to dismiss it. Let's get off our hands and let's, even though you don't have to prove anything, even though it's the prosecution has to prove things, if you have something that needs to be investigated, if you need to do something in order to present evidence to the police or to the prosecutors to show that you didn't do something, then you need to do it. It used to frustrate me as a prosecutor when defense lawyers say, well, he says he didn't do it, and they don't come to me with any information or data to support that conclusion. So we're very aggressive to make sure we present that data. Why is this so important? Because whether you did it or didn't do it, or you just choose not to take the plea offer that the government offers you, at the end of the day, it means it's going to go to trial, or you got to get another lawyer. Now, it's very important that you understand that before you can accept the plea in the state of New Jersey, you have to swear under oath in a courtroom to a judge that you are in fact guilty of the offense, and you have to give a truthful, factual basis to support the guilty plea. Either your lawyer or the prosecutor are going to ask you questions on such and such a day, at such and such a time. Were you in the area of such and such when you pulled out a firearm, fired that gun, and shot and killed so and so? And you have to answer those questions. That would be a plea for a murder case, for example. On such and such a day, were you driving your vehicle in a reckless manner? And as a result of driving in a reckless manner, were you under the influence of drugs or alcohol? Yes, you were. Okay, fine. And so died as a result of that. Is that accurate? You've just established a plea for reckless vehicular manslaughter, or rather, vehicular death by auto or manslaughter. So these things are important. You have to swear under oath the factual basis that makes you guilty. So your lawyer has to be prepared to go to trial, and you can't be put in a position where down the road, the worst thing that I'm hearing, and it's almost unbelievable, but I'm hearing with too greater frequency than I care to admit for the first time in 30 plus years of practice in law, clients are suggesting that the lawyers are saying, just lie and say you did it, so you can take the plea agreement and take the benefit of what the prosecutor is offering you. Well, any competent, ethical, and decent lawyer will never tell a client to lie, period, especially tell a client to lie under oath, especially tell a client to lie under oath in front of a judge. No decent, reputable, ethical attorney will do that. So you need to make sure that if you have not done this, or if you've done something less than what it is that they're charging you with, or if you just outright don't want to accept the plea, that when you're making the hiring decision for a lawyer, that you clearly state this and say, therefore, I don't want you jamming a plea down my throat down the road and telling me to say something that I did something that I didn't do. Are you going to take this case to trial? Key. And I'm saddened that I have to even make a video to say this, because it shouldn't be. Now, last point in this, You also have to make sure, because I'm listening to this is more and more of a problem, that you have a written, signed retainer agreement with the law firm that is going to spell out how the fee arrangement is going to take place up to and including a trial. Folks, it's my belief, and it always has been, and I've always trained lawyers this way, that the best lawyers to get the best pleas are the lawyers who prepare for trial. When you prepare for trial, and it's not just let's make a deal, like what Monty Hall was that, let's just make a deal. If the prosecutors respect that your lawyers are the real deal, that they're going to look for constitutional issues, going to look to file motions, that they're not afraid to go in front of a jury and to argue a case, and they're preparing as if they're going to trial, those are the lawyers that are going to get the beneficial plea offers, because the prosecutors know their case is not as strong with that kind of lawyer as opposed to a lawyer who holds your hands and pleads you guilty and tells you just lie to give a factual basis to get a plea. That's not a space you should be in, not a space any reputable, ethical, decent lawyer should put you in. I thought you should know this. I'm innocent. I didn't do this. Well, if that's a fact, you better let that lawyer know in advance and make sure it is crystal that they're a law firm and a lawyer that are willing to go, as we say, to the dance and try that case. I hope you found this interesting. You can always find us here at the Bianchi Law Group, the description below. We love doing these educational videos. I hope you find it interesting. If you do, please, as they say, hit that like button and smash subscribe at the Bianchi Law Group. Appreciate it. Thanks. Bye.